My name's Sid Mendelson, and I'll let the panelists this time introduce themselves.
My name's Tim Cox. I'm the branch of insurance products. I'm a branch chief.
I'm Joel Goldberg. I'm an associate director.
I'm Richard Grant. I'm special counsel to the director.
Tim, will you continue, please?
Yes, I want to conclude my remarks with just a brief oversight on Section 20, which is the proxy solicitation section of the Investment Company Act. It's basically, the section makes it unlawful to solicit proxies in contravention of any rules adopted by the Commission. The Commission generally adopted rules under that section, Rule 20A1A and 20A2. That section basically incorporates Section 14A of the 34 Act. And again, I think it's interesting that the rules of the Commission under the 40 Act, or the statute itself under the 40 Act, refer back to the 34 Act. The question might be asked as to why there's an incorporation by reference, so to speak, back to the 34 Act, and I think that probably the reason for that is that at the time the 34 Act was adopted, it was adopted in respect of those companies who had stock which were trading on an exchange, and it was not subsequently expanded to other issuers until 1966, I believe. The rules are basically disclosure rules under Section 20, and also with respect to 34 Act under Section 14. There's a Schedule 14A. I believe there are 23 items of information that must be responded to there. And under the 40 Act, there are 12 different criteria in the rules for 14A1. I just want to basically touch base. If it's an annual meeting and information, or if a solicitation is made for the election of directors, then there are 12 basic items of information that have to be responded to. In addition, if at that meeting there is going to be a new contract voted upon for the investment advisor, there is certain other information that must be added. These are all specified in the rules under Section 20. And I want to repeat once more that that's in addition to the information required under Schedule 14A on the 34 Act. And unless somebody has some questions specifically, move forward.
Do you have any questions? In other words, except with respect to specialized circumstances, when we elect directors, we talk about under the Investment Company Act, the rules provide you must discuss the contract, because after all, the advisory contract is the central point of the investment company area. With respect to that, with that exception, generally speaking, the proxy rules adopted under the 40 Act are identical to where applicable, to the proxy rules adopted under the 34 Act. Is that you through?
That's it, yes.
Okay, now we will turn to the next topic, which will be discussed by Joel Goldberg and Dick Grant.
Okay. We'll start with Section 22 of the Act, which regulates various aspects of the sale, redemption, and repurchase of redeemable shares. Primarily there we're talking about shares of open-end investment companies, mutual funds, more than anything else. In order to give you a little background to understand the complexities of Section 22, I just thought I'd say a few words about the way the distribution system works, without repeating too much of what you've already heard. As you know, an open-end company is somewhat unique in that it sells shares to the public continuously. At the same time, it stands ready to redeem or repurchase them at all times. Now, with normal securities, the price of the security is determined by what the market will bring. That's not the case with open-end investment companies. The price basically consists of the current net asset value per share, plus any sales load or sales charges that may be imposed. I'm just not going to get into a detailed explanation of how current net asset value per share is calculated. They'll go into that later. But basically, you add up the value of all the securities in the investment company's portfolio. If they're securities with respect to which there are readily ascertainable quotations, you use those. Otherwise, the directors of the investment company are required under Section 2A41 and Rule 2A4 to value in good faith. In the Commission's view, good faith valuation requires reference to market factors, so that if you're talking about a money market instrument, for instance, and there aren't any quotations in that particular instrument, you might use the valuations that were going for similar types of instruments. To use a simple example, if the investment company's portfolio is worth $100 and there are 10 shares outstanding, then the net asset value would be $10 per share.
Assuming there was no liabilities.
As I suggested, it's a little bit more complicated than that, and there will be a panel later on that will explain all the various variations. That was just the basics. So the price at which they are sold and redeemed is based on this current net asset value per share, and that's the basic concept. If they're sold, there may be sales load added. Occasionally, there's a fee on redemption as well. There are several basic ways in which investment company shares, mutual fund shares, are sold to the public. One way is for the investor to contact the company directly. A lot of NoLoad companies, that is, companies that don't impose any sales charge, operate that way. A second way is for shares to be sold through a captive dealer network. Perhaps the best example, certainly the largest example of that, is Investors Diversified Services, which offers a whole line of financial products, insurance products, as well as investment company shares, and they simply have their own sales force. The third basic way for the shares to be sold is through regular brokers and dealers. Now, Section 22 regulates a variety of aspects of this process. Briefly, it regulates transactions between investment companies and dealers. It regulates sales loads. It regulates computation of the net asset value. It regulates the public offering price. It regulates redemptions, restrictions on transferability or negotiability of investment company shares, and the method of payment for shares. Now, we'll take the subsections of Section 22 in order. Section 22A authorizes a registered national securities association to regulate the minimum price at which investment companies sell shares to members of the association and the maximum price at which members may redeem those shares. The association can also regulate the time that can elapse between a purchase and a redemption. A registered national securities association is basically a self-regulatory organization for brokers and dealers. There's only one. It's the National Association of Securities Dealers, or the NASD. The NASD does have rules of fair practice. Section 26 of those rules regulates investment company share sales. Subsection I addresses the question of the time period that can elapse between a purchase and a redemption, and it provides that if that happens within less than 7 business days, all sales loads received by the principal underwriter or a dealer have to be forfeited to the investment company. The minimum and maximum price at which the shares can be sold or redeemed is not regulated by the NASD, as I'll get into a little bit later. Section 22C gives the Commission the same authority to enact rules that 22A gives to the NASD, and the Commission has acted in this area. So the NASD, I guess, is preempted in that sense. Section 22B gives the NASD the authority to regulate sales loads to ensure that they're not excessive, to provide for reasonable compensation to sellers, but also reasonable sales loads for investors. The NASD does have a maximum sales load rule. It's rather complex, and I won't go into it in detail.
Dick, perhaps one comment we might make about that rule. Section 22B in its existing form was added to the Act as part of the 1970 amendments. And the maximum sales load rule provides in general a maximum sales load of 8.5%, which by coincidence is what all the funds had been charging prior to 1970 anyway, although the NASD maximum sales load rule under 22B does provide that certain discounts have to be given on quantity purchases and so forth, which might have been an improvement from the old situation.
That's right. Basically, the rule, which is Section 26D of the Rules of Fair Practice of the NASD, does permit a maximum sales load of no higher than 8.5%. But if you don't offer the right of reinvestment of dividends without sales charge, or if you don't offer rights of accumulation, that is, a discount based on cumulative purchases over a period of time, or if you don't offer volume discounts for purchases at the $10,000, $15,000, and $25,000 level, there's a sliding scale by which the maximum sales load could decline as low as about 6.25%. I think it is. Now, Section 22B also gives the Commission the authority to adopt similar types of rules regulating non-members of the NASD. Apparently there hasn't been any need for such a rule. As Joel said, the sales load really was never any higher in most cases than 8.5% anyway. That brings us to Section 22C, which, as I said earlier, gives the Commission the same authority to enact rules concerning minimum and maximum price for purchase and redemption that the NASD has. The purpose of both of those sections is to prevent dilution of the interests of shareholders. And to explain what dilution is, I'll go into just a bit of history. Before the Investment Company Act, the way fund shares were priced, just to use an example, the market value would be taken as of the end of business on Monday, and Tuesday's offering price would be based on that Monday valuation. In the case of a rising market on Tuesday, you could be pretty sure that when they took the valuation at the end of the day on Tuesday, it would be higher than it was on Monday, and therefore Wednesday's selling price would be higher than Tuesday's selling price.
In fact, I might even add here that if you knew what the fund's portfolio was, you wouldn't even have to estimate that.
It wouldn't even be a guess. You would you'd be able to do your own valuation.
It even got worse than that. Where the price would change at 4 o'clock, half hour after the New York Stock Exchange closed, and by 3:45, you knew the two prices. You knew today's price, and you knew tomorrow's price, so you could take your choice.
Now the difference might not be that great, but if you didn't have to pay any sales charges, and a lot of insiders and other people didn't, and you had enough money to speculate with, you could make a nice little return overnight. The solution to this problem, well, let me just say a little bit more about what constitutes dilution. It's fairly clear, but just by way of another example, if an investment company sells its shares for too little or gets too little for them on redemption, then everybody, all the other shareholders' interests are diluted. To take the example of the investment company with 10 shares outstanding and it's worth the portfolio worth $100. If I were to issue another share for free, that would be substantially less than it was worth. There would now be 11 shares outstanding worth a total of $100, so each share would only be worth $9 instead of $10, and that's dilution. The solution to the problem, which was adopted in the form of Rule 22C1, is called forward pricing. The rule requires that the current net asset value on which a sale or a redemption is made be based on the price which is next calculated after the order is received. So that if you put in an order at 2 o'clock in the afternoon, you don't know what price you're going to get until if the shares are then valued later in the day.
Dick, just part of the folklore, perhaps, of Rule 22C1, that was adopted in 1968, partly as a result of the Vietnam War. President Johnson, on a number of occasions, stopped the bombing of Hanoi for periods of time, and this was always announced late in the afternoon. Each time the bombing was stopped, the market shot up, and there was considerable trading in no-load funds during that period after the announcement had been made. And this happened enough times that the Commission decided to adopt Rule 22C1. So you see the SEC has got a certain interest in foreign policy.
Just to finish off on the requirements of Rule 22C1, the rule requires daily pricing in most cases at a time of day that's deemed suitable by the Board of Directors. The time of day used to be pegged to the close of the New York Stock Exchange, but with investment companies investing in securities that are traded all over the country as well as all over the world, in some cases, the close of business on the New York Stock Exchange might not be the most appropriate. The exceptions to daily pricing are that there does not have to be any valuation on the day when there are no purchase or redemption orders, and there doesn't have to be valuation unless there's enough trading in the investment company's underlying securities that there might be a material change in the net asset value per share. And that takes care of 22C. And do you want to move on?
The next section, of course, is 22D. Section 22D is one of the more mysterious sections of the Investment Company Act. Some might say they're all mysterious, but 22D has been the subject of a number of law review articles trying to explain what the purpose of it is, why it's in the Act. I don't think we're in the appropriate place to debate that here. Essentially, 22D says that a fund share and an open-end fund share can be sold only at an offering price described in the prospectus, and that has been interpreted to mean that whatever sales load the fund states, assuming it's a low-load fund, has to be charged to all investors. Everybody has to pay the same sales load. That is something of an anti-competitive section, I think. You can view it almost as a fair trade section of the law. Whatever the fund picks as its sales load, no dealer can discount that sales load. The investment company study, which is underway now in the division, is intending to consider whether that's a section that has perhaps outlived whatever purpose it once had, but it's still in the Act. There are several rules under Section 22D which provide various types of exemptions from it. The longest and most complex is Rule 22D1. Essentially, 22D1 says that you can reduce or eliminate the sales load, the published sales load in certain cases. In most of these cases, the reduction has to be described in the prospectus. That is, the prospectus has to tell that the load will be reduced so much if the following circumstances exist. One circumstance is where it's a large purchase, a quantity discount. A smaller load can be charged. Quantity discounts can also be made available to groups, provided certain conditions are met. Sales loads can be reduced for dividend reinvestment plans. I think in almost all cases I know of, dividend reinvestments are made at no load now. If they are not made at no load, as Dick indicated, then the maximum sales load rule requires a lower sales load overall. Sales to tax-qualified pension plans and other employee plans under Section 401 of the Code, and that's a bit tricky, incidentally, because some employee plans are qualified under other sections of the Code, 403. Rule 22D1 does not speak to that. The plan has to be qualified under Section 401, or sales to tax-exempt organizations qualified under Section 501 of the Code. That is, charitable organizations and other types. Sales to contractual plans are exempted from the 22D rule. So you pay your sales load when you buy the contractual plan. When that plan in turn turns around and buys the underlying shares to fund the plan, it need not pay the full need not pay any sales load. Other perhaps less important exemptions contained in Rule 22D1, where a company is raising its initial $100,000 in order to meet the requirements of Section 14A of the Act and need not pay sales loads, and sales to the directors, officers, or partners of the investment company or its investment advisor or its principal underwriter. Rule 22D2 is another exemptive rule providing relief from Section 22D. That is intended to take care of the situation where a shareholder redeems by mistake and quickly wants to come back in. Essentially, the rule says that if you have redeemed out of the fund within the past 30 days, you may buy shares equal to the amount that you redeemed within 30 days without paying the normal sales load, but you can only do that one time.
If I can interrupt for just a second, Joel. Sometimes the investor doesn't realize he's made a mistake until the fund salesman comes around and points out to him that he's made a mistake.
Yes, and under Rule 22D2, if the fund so chooses, the fund salesman won't be paid for pointing that out, which, so we don't know whether Rule 22D2 doesn't prevent people from ever finding out about their mistake. That privilege can only be exercised one time, incidentally, for each shareholder. Then there's Rule 22D3, which exempts variable annuities from Section 22D. Just the types of charges they make and the state laws they're subject to and other factors just don't make it practical to subject them to Section 22D. I might point out that the mere fact that you see a reduced or no-load sale, which doesn't fit under any of the categories I've talked about, does not mean it's illegal. We have given a number of individual exemptive orders in recent years under under Section 22D to provide for relief on the sales load in all kinds of situations, and you might want to check and see whether there's an exemptive order outstanding.
Well, the exemptive order would only be for the particular company,
Right,
Joe.
right,
So
right.
to the extent that some other company wants to do it, it would be illegal.
Oh.
But what you're really saying is if that company wishes to come in on the same terms, the chances are it would get the same order.
Well, I'm saying that, and I'm saying also that we've given such a large number of orders in this area that it's quite possible that the company you're looking at has its own order. It's something,
yes.
something to check.
Certainly.
I think our thinking in this has been that 22D, to the extent it protects anyone, probably protects the underwriter and the dealer by discouraging price competition in the sales of shares.
Well, I think that in fairness, 22D it was enacted to protect the distribution process. Now, over the years, I think that it's fair to say that the interpretations of 22D carried it way farther than its original purpose.
I might just expand on that slightly, Sid. When Sid says that it was intended to protect the distribution process, the argument for that theory is that mutual funds frequently are sold to unsophisticated investors who need considerable explanation and selling effort in relation to the size of the investment they make. And if a fund dealer is going to spend several hours explaining to somebody why he should invest $1,000 or $2,000 in the fund, he should be assured that if he can make the sale, he'll get the full sales load. If the investor, having been educated, can then go down the street and buy the shares from somebody else without paying the full sales load, then dealers won't have an incentive to push shares or to educate investors, if you want to put it that way. I don't know how persuasive that argument is, but I think it is the classical argument.
There's another argument also that where a big organization can go into any area and literally price cut by everybody out of existence, and then it has the feel to itself, and it brings the price back up to the load suggested in the prospectus. In the meantime, the selling ability of the fund, the distribution process of the fund, let's assume there were 10 dealers in the area, and some big organization comes in and charges 0.5% load on this. It's obvious that those other dealers will be looking for other products to sell, and therefore, when and if the big organization moves back into the regular price, it may do so minus any competition, and there won't be and as far as the fund is concerned, it won't have those 10 or 12 dealers to go out and sell in that particular area. So it's interested in getting as a large number of dealers as possible.
Yes, sir.
Sid, don't you think that problem is even more likely now in light of the fact that some of your larger mutual fund complexes, for instance, Fidelity, has started to engage in the discount brokerage business, and by doing that are encouraging a lot of small investors to use their brokerage services?
Well, yes. The question is, it's pointed out that, for example, Fidelity is in the discount brokerage business, and they're taking business away from funds and encouraging small investors to use their services. I think that's true. I also should point out to you that Fidelity, one of the companies who used to exclusively sell by NoLoad, is selling a good number of their investment companies now by load, is now selling by NoLoad. And there is a tendency today to sell shares, particularly, obviously, money market funds cannot be sold at a load because the competition is the bottom line. How much yield am I making? People go in and out of those every 60 or 90 days. And to have to pay a load on those kind of investments would make it impossible for people to go in and get any kind of a yield at all.
Well, Sid, I think what you point out about the trend toward more no-load sales is true even in the stock funds.
Oh, absolutely. I was just saying, I was pointing that out to with respect to a specific type of fund. But today, with the relaxation of advertising under Rule 134 of the 33 Act, there are more companies that are forsaking the load, and that combined with the increased sophistication of people looking toward no loads have increased the number of no load funds. So I don't think 22D will go out of existence as a natural consequence of no load funds. But I do think people that when a company is selling at no load, 22D is hardly applicable.
Well, I think that whatever the future of 22D, we've probably given it as much time as it deserves. Dick, do you want to go on with the rest of 22?
Sure. We've talked about selling shares. Now we'll talk about redeeming them. Section 22E requires that shares be redeemed within 7 days after a tender for redemption, except in certain circumstances. Basically, those circumstances are when the New York Stock Exchange is closed other than regular weekends and holidays, or if trading is restricted on the New York Stock Exchange. Second, if an emergency exists under which the investment company can't dispose of its portfolio securities or can't value its portfolio securities. And third, if the Commission gives an order permitting it. Now, the Commission has rulemaking authority to define what constitutes restricted trading on the New York Stock Exchange and what constitutes an emergency. The Commission hasn't exercised that rulemaking power except for Rule 22E1, which is a highly specialized rule for variable annuities. So basically, the only way for funds to suspend redemption of securities is to get an order from the Commission. The Commission has given a few orders in individual cases where it seemed to be appropriate. Section 22F.
I'd like to spend a little more time on 22E just for a second. The requirement of 22E that securities must be redeemed within 7 days, and they have to be pegged as of the time that the redemption request is received, is one of the big points of a mutual fund, and one of the things that triggers an emergency inspection is complaints that the fund is not redeeming. When a fund is not redeeming, generally speaking, it's because something is wrong with the fund. Either they can't figure out their net asset value, or they somehow for some reason or other, their assets aren't available, or something of that sort. So I can only say to you that when you find a complaint that I'm from an investor that I'm not getting my money when I ask for redemption, it's something that cannot be ignored. We have to go in. It's one of the big danger signals with respect to the controls over the fund.
Sid, I might just add to that it will occasionally take the form of not the fund refusing to redeem, but coming up with all kinds of excuses not to redeem.
Yes.
The redemption form wasn't in quite the right order, something like that. As Sid points out, that could be a danger signal.
Problems with redemptions is the biggest single source of complaints we have in the division. Most of them don't suggest that the fund's in any trouble, but they may suggest that the fund's a little bit less interested in redemptions than it is in some other aspects of its operations.
It depends upon what the complaint is. Obviously, many times the fund is perfectly justified in refusing redemption if the request is not properly filled out, and the stock is made in the names of the husband and wife as joint owners, and only the husband or only the wife signs. Obviously, the fund can't legally redeem the securities, and that isn't what I'm talking about. It's the kind of thing that a person sends in a redemption, and he gets a call on the phone. How about taking 25% now and 25% next week and 25% the week after, and the remainder when we can get it? This is the kind of buzz that usually results in an inspection, and that inspection will in all probability find something wrong, because my experience has been when the fund receives a properly executed request for redemption and doesn't execute it, something is wrong.
Okay, moving along to Section 22F. 22F permits a fund to restrict the transferability or negotiability of its shares only in a manner described in the registration statement. It also gives the Commission rulemaking authority in this area, but the Commission hasn't exercised that authority. I think this is an appropriate point to discuss another aspect of the distribution system, which is that, as I suggested earlier, in the case of most stocks that are other stocks other than investment companies that are issued to the public, there then develops a secondary trading market, perhaps on a stock exchange or in the over-the-counter market. There is no secondary market in mutual fund or open-end investment company shares as such. There was, prior to the enactment of the 40 Act, it was frequently called the bootleg market, and it was used for speculation, and which would frequently have a dilutive effect of the kind I described before. Subsequent to the adoption of the Act, the system that evolved imposed restrictions on those who dealt in mutual fund shares, which had the effect of prohibiting the development of a secondary market. The Justice Department challenged those agreements and restrictions a number of years ago in the case of US v. NASD, alleging that they violated the Sherman Antitrust Act. The Supreme Court decided against the Justice Department on the theory that Section 22F, by permitting restrictions on transferability and negotiability, and in general providing a pervasive regulatory control by the Commission, granted antitrust immunity. Do you want to?
Dick, I might just add one interesting aspect of that case. The court, in holding that 22F, in effect, cloaked these agreements with antitrust immunity, held that despite the fact that the Commission hadn't adopted any rules under 22F. The court held that by not adopting rules to prohibit these agreements, when the Commission knew that the agreements existed, that in effect amounted to a decision by the Commission to allow the agreements, and that was part of the court's decision.
Right. The final section of subsection of Section 22 is 22G, which provides that a fund cannot sell its shares for services or for property other than cash or securities, except in the case of stock dividends or distributions or in connection with a reorganization. Don't have any other comment on that.
Well, this is very. I think this is very important, in that, as you know, particularly people who have been dealing with regular commercial companies, that they are organized in the the promoters either give the land or give a building or something of that sort, and are issue or give services, and for that they end up with 51% of the stock, the promoter's stock. This section is very important because this is the area that prevents an investment company from being diluted in the same way a commercial company would be diluted by the promoters coming in and taking all kinds of stock for services. So when it says that securities, that the only thing that stock can be issued for here is for cash or for securities, both of which have a value and which can be ascertained through the machinery provided by the Act. Of course, cash is cash, but the securities, the valuation of securities is clearly set forth. How securities are to be valued. Accordingly, the dilution effect of a promoter's stock and stock purchases by insiders or favored people is almost eliminated by this particular section alone. Yeah.
Okay.
All of Section 22 relates to open-end funds, as Dick said. The distribution of closed-end fund shares comes under Section 23. Section 23 is a much shorter and more simple section because the distribution systems of closed-end funds are much simpler than those of open-end funds. They, of course, don't redeem shares. Section 23A says that a closed-end company can issue securities only for cash or securities, except in certain specified circumstances. That would be in connection with a dividend or a distribution to shareholders or a reorganization, and that's got the same purpose that Sid just described in the case of open-end funds, to prevent insiders from contributing property and taking shares which are worth more than the property is. Section 23B of the Act prohibits a closed-end fund from issuing shares at less than net asset value, determined as of 48 hours previously. Now, that, of course, is not the same as Rule 22C1, which, as Dick explained, requires forward pricing to determine net asset value. A closed-end company can price up to 2 days prior to the sale, base the price upon the asset value 2 days earlier. The danger of trading against the fund, riskless trading, is, of course, not present in the case of a closed-end fund, because once you've bought the shares, they can't be redeemed. So provided that the error in asset value, if you will, provided the amount that you pay is pretty close to the actual asset value, there's no great harm done by a small error. Section 23B contains certain exceptions from the requirement that you can't sell shares at less than net asset value. The first, and probably the most important, is where the company is making an offering to its own shareholders. Now, as a general matter, when closed-end fund shares trade in the secondary market, they generally trade at a discount from their net asset value. There have been various economic theories as to why that's so, but it is generally so. Now that means if a closed-end fund wanted to offer more shares, it would probably have to offer them at less than net asset value. Nobody would pay full asset value, and they can buy them on the secondary market cheaper. Now, it's become common in the past several years when closed-end funds do want to expand their asset base and issue more shares, to make what they call a transferable rights offering to shareholders. That is to say, all right, we're going to come within the exception to 23B. We're going to issue shares at less than net asset value to our existing shareholders. But to the extent that these shares are not all taken up by the shareholders, then members of the general public can take up the remaining shares. The Commission issued a release, Investment Company Act Release 9932, to discuss the circumstances under which one of these transferable rights offerings would be regarded as coming in within the exception of 23B. Obviously, you don't want to allow these transferable rights offerings to be a mere cover to issue shares to the entire world at less than net asset value. That might be in the interest of the investment advisor, because it'll increase the total size of the closed-end fund and thus the investment advisor's fee, but it would dilute the interest of the shareholders for the same reasons Dick explained that the open-end fund's shareholders' interest would be diluted if people can come in and pay less than full asset value. In Release 9932, the Commission said that there were a number of factors to consider when deciding whether one of these transferable rights offerings is a legitimate offering to shareholders that would come under 23B. One of the factors is whether there's a reasonable expectation that the shareholders will take up all or almost all of the shares being offered. If you've got a total of 1,000 shares outstanding and you issue 30,000 more shares, you have to assume that people won't take them all up. Looking at past experience with any other offerings the company can make and other factors might indicate whether the directors can reasonably find that the offering will be proper. Now, I should point out that even if an offer is proper under Section 23B, that is an offer at less than net asset value, you still have a question whether it's a proper exercise of the director's discretion with regard to their fiduciary responsibility under Section 36. There will invariably be some shareholders who either can't afford or who don't choose to buy shares as part of the offer, and their interest will be diluted in considering whether this was proper under the director's fiduciary duty. You should look to what the fund intends to do with the money, whether an increase in its asset base would substantially lower expenses or would otherwise help the fund in some demonstrable way. Other exceptions to 23B, other ways that a closed-end fund can offer shares below net asset value, is with a consent of the majority of its shareholders, although again that would not excuse the directors of the fund from any any breach of fiduciary duty in authorizing the offer, a conversion of convertible securities, or pursuant to commission rules. Section 23C of the Act regulates the circumstances under which a closed-end company can purchase its own shares or redeem its own shares. A company can purchase its own shares on a stock exchange subject to such rules as the Commission may permit. There are two rules under Section 23C1 regulating the repurchase and redemption of closed-end fund shares. One essentially says that you can purchase them provided that the closed-end fund is not purchasing them from affiliated persons. Proper notice is given to all concerned, and a number of other requirements are met. That's Rule 23C1.
Is that to everybody, Joe?
Yes.
The purpose of the restriction, as you might understand, is to prevent the fund from buying off a dissident stockholder.
Sid, I think you're speaking, of Rule 23C2.
I'm talking about this part of Section 23. The purpose of the section is to prevent favoritism, either to pay off a dissatisfied stockholder, or to pay or to let some insider, if you will, some favorite stockholder get out. Favoritism among stockholders.
In fact, Rule 23C2 makes that quite explicit. Says that if a closed-end company redeems any of its shares, the redemption has to be based either on a pro rata basis of all shares outstanding, or by some other system such as drawing lots that will eliminate favoritism on the one hand, and as Sid said, will eliminate prevent the company from buying off redeeming out shareholders who are causing trouble for management, or who they want out of the fund for some reason. A general rule under Section 23C: anytime a closed-end fund purchases shares under any of these provisions, it must give must within the preceding 6 months have informed all shareholders of its intention to repurchase shares. I think that wraps up both 22 and 23, Sid.
Yes. Are there any questions?
One over here.
Yes, sir.
I wanted to ask a question about 22D and 23B. In 22D, you can't sell shares below the public offering price, but there's an exception where you sell to your security holders if the offering is proportionate to the holder. And then in 23B, there's an exception for offering the sale by a closed-end company of shares below the net asset value in connection with the offering to the holders, and there's no proportionality requirement.
Well, let me try in the 22D question you asked. That is, you noticed that there was a proportionate that shares can be sold in pro rata to the shareholders. We took up until recently, we took the position that the investment company could not be selling shares to the public at one price and selling shares to its own shareholders at a different price under 22D. We in a release which I do not have a copy of and can't give you a citation, but it's a release within a year, approximately a year. We took the position that the simultaneous transactions could take place. You could be selling to shareholders at one price and selling to the public at another price pursuant to that provision. And there, obviously, I don't think that there's any we ever expected and still don't expect that the shares will be sold below net asset value.
Sid, I might just add there, Section 22D and Section 23 really don't speak to the same thing. 22D, of course, speaks only to the sales load. You still have 22A and 22C preventing sales below net asset value. So all that exception in 22D does is enable you to waive the sales load to investors. Now, with respect to investors who have previously invested. Now, if you had the same provision in Section 23B, if you could make a proportionate offer to shareholders, that might mean that you could offer each shareholder of the closed-end fund, let's say 10 times his existing holdings, 20 times, and people who were unable or unwilling to take advantage of that offer could suffer dilution if the offer were made below asset value. That's isn't a problem under 22.
I agree entirely with Joel that there's no dilution under 22D with respect to the provision that you suggested, but there would be dilution under 23. Any other questions? If not, we'll commence the next session tomorrow.